Welcome, everybody. My name is Kent Newton. I'm very glad you're here for a lot of reasons. Two, primarily. I have the honor of serving on the COIN board. COIN, as you know, is a facilitator, a platform to put together events like this with our wonderful partners. Also, I'm very pleased that you're here because I am a volunteer at the Jewish Community Center, where we're fond of saying that community is our middle name. We have the JCC to thank for being a host as well as being a financial sponsor of this program. Camille Arnett, who is Director of Arts and Education, will be in and out. She has a table here with JCC information. The U.S. Department of Labor Wage and Hour Division, Department of Workforce Development, and these wonderful organizations you see at the tables have all come together to share some important information, to make some important contacts, and to help together to serve our immigrant sisters and brothers. We're fortunate to have some very qualified and experienced presenters today. We have a full program. I hope it'll be informative and useful. Some housekeeping information in addition to the refreshments, which, by the way, are very healthy, delicious, and kosher, and we have to eat them all. We can't take them back into the kosher kitchen, so that's your responsibility. We have the restrooms are out the door to your right, and take a right, very useful information. There's a QR code on a little tab of paper on the chair in front of you, except for the front row. That's a survey. So at the conclusion or toward the end of our program, would you scan the QR code and answer a few questions to tell us how we're doing and how we can do things better and how we can address issues from the future. The format today will be our featured speaker, after whom we'll have some questions and answers. We'll have a break to eat the food. We'll have then a panel discussion with some very qualified people, some questions directed to them, and then some audience Q&A. Recommend that during the break and after our formal presentation, you explore some of the tables that are here. These folks are very dedicated, experienced people on the front lines of immigrant issues and immigrant services. If you feel that you want to help either financially or with your services of yourself, volunteering, they will be glad to talk to you. We have a video that we're making of this event. It's for wider use. If you don't want to be in the video, please sit in the chairs to your back right, and we'll try not to capture your beautiful countenance. A couple of statistics, and I know I'm preaching to the choir, but I need to share a couple of things that I think encapsulate and perhaps set the stage for what we're trying to do today and give some objective perspective. The most recent statistics from the American Immigration Council say for Indiana, and numbers change, as you know, from time to time, but Indiana we're blessed with 423,000 immigrants, 1,000 of whom are not documented. The economic aspects are very, I think, compelling and very persuasive. For 2022, the total spending power of immigrants in Indiana was $12.3 billion. They paid $4.3 billion in local, state, and federal taxes. Our state has 25,200 immigrant entrepreneurs with a total business income of $794 million. They are part of the fabric of our state, and we're pleased. The qualifications of our presenters and our speakers are long. They are experienced. They've not only been in executive and managerial positions, they have been in the trenches, literally in the front lines of helping our immigrant sisters and brothers. If I were to go through all their credentials, we'd be here all day. Our primary speaker is Lacey Houle, who is now with the Department of Labor Wage and Hour Division. She's been there since 2016. She was 5 years as an investigator in the trenches, in the front lines. She is the Community Outreach and Resource Planning Specialist. We'll have time for some Q&A after Lacey's presentation, and then we'll like to introduce the rest of the panel members after Lacey's presentation, Q&A, and a time to eat our snacks. Lacey Houle.
I have a big jug of water here, so hopefully I don't have to drink a lot of that. But thank you guys for coming. Thank you, Kent, and the Coalition for setting this up, and yes, for the Community Center for hosting. So as he said, my name is Lacey Houle. I'm going to try to lower this a little bit so you can see. And so, yes, I'm the outreach specialist for the United States Department of Labor, Wage Hour Division. How many of you have heard of the Wage Hour Division? Okay, that's good, that's good. So that's a question when I was an investigator that employers would always say, I never knew you existed, I never knew you were here. So they always think about the State Department of Labor, but we are at the federal level, okay? And so today I'm just going to kind of give you an overview of the Fair Labor Standards Act, FLSA, and then a few other acts that we do also enforce. We have several different laws and acts that we enforce. And so that's what, when we share this information, the public is like, wow, you do a lot. So we do. So I'm just going to dive right in, and we're going to cover a lot of things. Some of it's just going to be a general overview just so that you can hear it, you're aware of it, you know who to contact if you come across it, okay? And then, yeah, we'll try to do some questions and answers afterwards. But first, I have to display this long disclaimer. I'm not going to read that, but just the information that's going to be given today is basically just general information. It's not going to be legal for us. We obviously, look at our regulations and for the actual information that we're going to need whenever we, do our investigations. So here's just an outline of kind of all the different kind of topics that we're going to talk about. So you can see misclassification, employment relationship, hours worked, some common violations that we do see when we're out in the field and investigating employers. So that's typically what we do. Our investigators are all throughout Indiana, and I think we have about 10 here across the state. And so our mission and our goal is to promote compliance and have protections for workers to make sure that they're paid correctly. Okay, and so we go out, we check compliance with employers to make sure that yes, we do have compliance. If there are violations, then we're working with that employer to correct those and to get them in compliance. You may have heard some of our cases on the news, and so that's obviously something that we also do is try to use media to help. One, whether to get the information out to the workers, because there might be industries of, hey, that's happening in my industry, or there's also employers, hey, I'm doing this for my worker or my business, so this is not obviously legal. I should be straightening up my act and coming to compliance before the Wage Hour Division comes and investigates. And so first, obviously for us, the Wage Hour Division, to come in and to enforce minimum wage and overtime, we have to have an employment relationship. Okay, there has to be a relationship between the employee and the employer. Okay, so what we see a lot of times is, employers will hand a 1099 form, to the worker, and the worker may not even know what this form is. And so this could be a misclassification of employment or relationship, because they should technically, most likely, are going to be employees. When an employer, you go work for an employer, typically you're going to be an employee of that person. If you're a 1099, an independent contractor, then you're more likely to be in business for yourself. You're advertising for yourself, you have your logo, you're using your own equipment and so forth. And so we see a lot of misclassification with independent contractors when truly they should be classified as an employee. And so, when we see this misclassification, that's obviously affecting the worker. And it's affecting us as the state of Indiana. It's obviously the benefits with tax and so forth. It's affecting that as well. So, that's something that we do look into as part of our investigation process, is we want to make sure that these employees are classified as employees and not independent contractors. And so when we ask for these tax forms, or 1099 forms from the employers, that's what we're looking at. And we're checking, and we're going to look at these factors to see, are they truly in business for themselves as an independent contractor, or really are they misclassified and should be an employee? Okay. We don't, rely on titles of, like I said, of things like that. So like I said, more likely they're going to be employees that we see. And so here's just a list of, obviously, some of the, I always forget, I have a screen back here that I can look at instead of looking at the screen. We have, to the left is obviously what the benefits would be denied from the workers, right? So it's not just minimum wage and overtime for us as the Wage Hour Division, but they're also missing out on health insurance. They're missing out on workers' comp. They're missing out on potentially applying for unemployment if they need to. And so even when you have a worker, like I said, sometimes They show up, they're working, and it's going to happen to a lot of vulnerable workers, maybe workers who, yes, are not fluent in English. And so, like I said, they could be handed a 1099 and may not even know what this is. Sometimes we have workers that will agree with the employer, or they come to the employer and they say, I want to be classified as a 1099. And so that cannot happen unless you're truly in business for yourself as an independent contractor, okay? So the way I like to think of it is that if I'm a restaurant owner and I have a landscaping company that's coming out to mow my yard, or to mow, clean, do my landscaping and so forth, they're more than likely going to be in business for themselves, and I can classify them as a 1099 independent contractor. They have their own employees and they're, doing work for multiple people, not just for one person, okay? So that we do see that a lot too, that, like I said, they agree, they sign an agreement. Just because they do that doesn't automatically mean that they're a 1099 independent contractor, okay? And so, like I said, just because they label them, it doesn't mean that. So always be on the look for that, because like I said, this is a common violation that we're starting to see a lot of, is the misclassification. And then we did have a final rule come out with this for the independent contractor. And so that became effective on March 11th of 2024. And so basically this final rule, devised from 2021. Obviously, it helps us as the wage hour division how to analyze who is an employee or an independent contractor. And so we look at factors. So now we have 6 factors instead of 5. Okay, and so we're looking at each of these factors. And so some of the factors I think are listed a little bit here on the slide of kind of what the changes were in the final rule. So like this first bullet point here, when we look at the factor, not one factor is going to have more weight compared to the other factor. So we're kind of looking at the totality of all factors that are given, and we do have fact sheets on that. It's fact sheet number 13. I didn't bring any with me today, but it kind of explains what some of those factors are. And you can Google just fact sheet number 13 and it'll pull up for us that you can have. And we have those in multiple different languages. But the second bullet point here, like I said, we're now having 6 factors instead of 5, and then part of that's including the investments that's made by the worker and the potential employer. Okay, so that's how we're going to single and determine whether or not we have that relationship. When we talk about provides additional analysis of control, so that's what we're looking at. Who's scheduling? How is scheduling being done? What about the supervision? What about the price setting? The ability to work for others, should be considered when analyzing the nature and the degree of control of the worker. So that's what we're really looking at on that. Who has the control? Like, are they setting their own schedule? Are they negotiating and so forth? And then not one of the last bullet points, but the provides additional context to some factors. This is obviously going to include discussions of exclusivity in the context of the primacy, right? So we see that a lot too. How often or how frequently are these workers working for the same individual? Okay, so if we're seeing this is happening over a 5-year period, that's kind of raising a flag to us that you more look like an employee rather than an independent contractor. Okay, so we did have this just come out, and like I said, became effective on March 11th, so just wanted to share some information on that with you as well. And so what allows wage hour division to come in to do investigations, okay? So we talk with some language that we say that the general public is like, what are you talking about? So this is one of them, coverage. So what makes the law applicable to the employer, so where we come in and what provides the protections to the workers, okay? So we have 2 types of coverage. The first one is going to be enterprise coverage, and that's where you have employer who's earning at least $500,000 a year in sales, and they have 2 or more full-time employees that's engaged in commerce and the production of goods for commerce. So pretty much everything that we're handling on a daily basis, working with, has come across state lines in some form or fashion, okay? And so when we have enterprise coverage, which is the most common coverage that we do see, this is going to include all employees within the establishment. If you have an employer that has multiple locations, we're also going to include all of those locations into that one enterprise, okay? So if we have a small mom and pop shop, they've not established themselves yet, they've not made $500,000 a year, we're going to look at individual coverage. What are the employees doing individually, to where the protections would still apply to them for minimum wage, overtime, record keeping, and child labor. And so, are those employees, are they swiping credit cards and the transactions are going across state lines? Are they, working in a manufacturing plant that's shipping goods that's going to go across state lines? So those are what we're going to look at. And so when we look at the individual coverage, That can come in on a work week by work week basis that we're looking at. Are they regularly doing this on a daily basis? And so you might have some employees in the establishment that might be covered, and you might have some employees that aren't. Okay, so that's what we just have to look at through our fact finding of our investigations. But this is really what makes the law applicable of how the protections would apply to the workers. And minimum wage. So the federal minimum wage is $7.25. And this is one of the violations that we, obviously will check in when we do our investigations. So, this is a calculation of how we would calculate this. It seems pretty easy, but we see a lot of issues with this. So basically you're taking, the total payment, the total compensation, your gross weekly pay, and you're dividing it back by all hours worked to get your regular rate, basically. And so in this example, you can see an employee earned $369.23, divided by 40 hours that work week, and then their regular rate's $9.23. This is very important for workers to understand how much they're being paid, because they could be told they're going to be paid $10 an hour or $15 an hour, and then may have deductions and so forth, which we're going to talk about, and then they don't know what their actual regular rate is by the time they get paid. So it's important for workers to understand when they're looking at their pay stubs, or if they're paid in cash, am I paid at least the federal minimum wage, or do we have a violation? Okay. And so when we talk about minimum wage, what's included, right? So these are all the things that would be included. So obviously an employer, and to determine whether an employee obviously has been paid the minimum wage, they have to, look at all hours worked in each work week, and then you have to add up all the compensation that's received, and again, divide that by all hours worked. So, these payments would include salary payment, piece rate payment, or any type of, hourly rate. What we've been seeing an increase is bonuses, so non-discretionary bonuses, especially during COVID, and then now since COVID, employers have been, giving bonuses out to employees, and just going above and beyond, trying to pay overtime, trying to give bonus, but their employers aren't familiar or have an understanding that they may need to include this into the regular rate and overtime work weeks if the employee is working overtime. So all of these things would be considered as total compensation that they would need to go into. Shift differentials, that's another thing that we see some issues with in the home health care industry, in nursing homes, hospitals, and things where they're working 24-hour shifts. And so obviously an employer, should not determine the amount of money to pay an employee without knowing the number of hours that the employee has to work, right? So it's the employer's duty to ensure that work is not performed if the employer doesn't want it to perform. This is something that we do see a lot of issues with, and something that I came across when I was an investigator. I'd have an employer come in and they would say, well, Lacey, I told them that they shouldn't be coming in before their shift, and they're still doing it, and I shouldn't have to pay for that. So that's not an excuse. The employer knew that the work was happening. They allowed it to happen. They didn't discipline or, take care of the situation. So those hours still have to be paid and counted as hours worked. Okay. They can't accept the benefits, of that employee's labor and not compensating them for that work. Okay. So some examples that we would see, try to move my mouse down here where I've lost it. Some examples that we would see. I moved. Excuse me. Bear with me real quick. I don't know where it went. There it is. Okay, I'm back up. Sorry. Got ahead. So what we see with that would be like roll call, or it's like pre-shift, post-shift work. We have employees coming in ahead of time, or staying after work, going ahead and clocking out, but then still not being paid for that time. On-call time, that would be considered hours worked. Sometimes we have employers that are traveling multiple work sites throughout the day. That would need to be time as hours worked. And then like I said, any type of training, hazmat, like if you're working in manufacturing or some type of a plant where they have to don and doff with safety equipment and so forth, that would need to be considered hours worked. Okay. And so here's, in the next few slides, I just have a couple examples of what some of these common issues with hours worked that we see. So waiting time. We have two different charts here of what would be considered hours worked, what would not be considered hours worked. So if you have, I'm just going to use an example of like a care worker, right? If they're working from 8 to 4, 8 a.m. to 4 p.m., let's say in a residential or a nursing home facility, and they, the residents are taking a nap between 12 to 2 p.m., right? So the employees are required to be available in case if there's a resident that wakes up or they need to assist, with any type of, helping them to the restroom or whatnot. They're engaged to wait, so they would have to be paid for that time. Okay. Now, if the employee was able to leave the premises between that 12 and 2, they don't have to stay there, then that would not be considered hours worked, and they would not have to be paid for that time. Okay. On call time. So, we see this a lot where we have a lot of employees that are on call, working. Let's say we have an example of a worker that's working a shift from 7 a.m. to 3:30 p.m. There's a bad storm coming in, and the employees are asked to stay until 4:30. Okay, so they get off at 3:30 typically. They're asked to stay till 4:30 because they're maybe the employees that are coming in because of the storm may be arriving late. So the employer is having them stay till 4:30, an extra hour. The employees aren't doing any work. They're just waiting here just in case. That still needs to be paid because they're required to stay on the premises, on the employer's premises until that time. Okay. Let's say that you have a driver who is once a month, every Monday, or one Monday a month, they're on call, right? And so they can go home, do their, attend their chores, do any type of social event, so forth. They just have to, be within 30 minutes of their facility, of being called. And that driver gets called, and they have to respond, to a call. They're going somewhere, and let's say that takes 2 hours, right? That 2 hour time would need to be paid for. Okay, even though the employee can go back at the end of the call and still go about their personal affairs, that would not need to be paid for. Only the 2 hours that they're doing the work for would need to be paid for. So we do see some cases like employers, they will put restrictions, with the on-call folks of, if you're a driver, you have to, show up and, you can't drink alcohol, right? So they can have some of those restrictions on that, and that necessarily wouldn't need to be, paid for time work. Only the time that they're responding to the calls would that need to be paid for. And meetings and trainings. This is obviously another common violation that we see. So the time spent where workers are attending any type of lectures, meetings, trainings, training programs, or any type of similar activities, that can and can't be, or may or may not be hours worked. It's just obviously depending on criteria. So we do have some criteria that they would have to abide by in order for that to, whether it's considered paid or not. So where it wouldn't necessarily be paid, as long as if the attendance is outside their regular work hours, if it's voluntary, it's not really job related, and then obviously the employee is not performing any type of productive work, then that necessarily wouldn't have to be paid for. But most of the time, the key word here is mandatory, right? So when the employer is mandatory, making you do something, it needs to be paid for. And we see that a lot with orientation, right? They might have to show up for a week or two, get some training and so forth, so they at least have to be paid $7.25 an hour, the minimum wage. And that's like if you have someone that's, going to a mandatory CPR training, that orientation have to be paid for that. And so in our experience, like what we see is, the meetings, like shift exchange meetings, like in a hospital maybe, or where you have someone come to kind of understand what's happening throughout the day, right? And we're taking maybe 15 minutes to have that conversation. A lot of times employers may not pay for that time, and they should be paying for that time. And that's what we see because, 15 minutes a day, or going to a safety meeting 15 minutes a day, every day for 5 days a week, that adds up to 75 minutes of unpaid work. And that can put that employee into overtime that's not being paid correctly. Travel time, another common issue that we see, and this is a lot in the home healthcare industry, even in construction industry. So it's, anytime you have an employee that is driving from multiple sites to site. So our typical home to work commute is not going to be paid time. Okay, that's typically we drive home or from home to work, and then from the work site to home. That's not going to be paid. So where it would count is obviously if yes, I'm home health aide. I have to go to home A for maybe a couple hours, and I have to go to home B for a couple hours. Home C, all that time in between there would have to be paid for, unless I have that time where I have personal affairs. I can do that time freely. I don't have to show up to my next client's home until 2 hours, so I have time to run to the store or do a couple errands. That time necessarily wouldn't have to be paid for. So it's, again, if you're going from site to site directly, then that time would be compensated. It's all in a day's work, pretty much. Rest and meal periods. So there's no federal law I don't want to see, I might see some faces that are shocked, right? So there's no federal law that requires an employer to provide an employee with a rest or meal break. State law may be different. You want to check with state law. However, the law would state under federal law that if the employer is giving employees breaks, 20 minutes or less would need to be paid for. Okay, so the employee can choose to do whatever they need to do on that 15-minute break, need to be paid for. And then the meal breaks, as long as they're free and clear, they're not doing any type of work, 30 minutes or more, then the employer does not have to pay for that. Okay, so it's ideally good, right? To, it's going to be the benefit of the employee, help, give some more energy to the employee, and it's going to help with the production, with the employer. But some employers don't do that. But this is where we would come in and enforce that. What we see a lot of is that the employers will automatically make deductions, 30-minute deductions for lunches. And that's okay, as long as they're keeping track of that, and obviously as the employees are truly taking their lunch and they're free and clear. Sometimes we see workers that are sitting at a front desk and they're still, the phone may ring, it may not ring, but they're still sitting there and they're not free and clear. That time would still need to be compensable. They need to be paid for that. And so those are the issues that we see with the employers. Or I had a case, years ago where it was just a small little mobile store and it was just one worker. And that worker, never could eat, but if a customer came in, they'd have to tend to that customer. All that time would have to be paid for. They're not truly free and clear where they can go, outside the view of the public and enjoy their lunch. So those are just some of the differences and some of the common violations that we see with lunch breaks. Another thing is that, they make those deductions. I think I already said this, but they make those deductions and the employees truly aren't taking the lunch. And then sometimes the workers are like, we still tell them we didn't get a lunch that day and they still deduct that. So that's something that workers need to be aware of. Just, they're paying attention to make sure that, okay, I didn't take a lunch today, I need to make sure I was compensated for that time. Because again, 30 minutes a day, that's 2.5 hours a week. That could be cutting into their overtime. And then just real quick, this is one of the other acts that we enforce, the Pump Act. And so we just had some recently new guidance on this to where this is now opened up to more workers and more industries. So before it would exempt the employees to have the protection to pump at work, right? So now it's opened up to more. So we have farm workers that it's available to. We have transportation, we have teachers, and I think I don't have them all memorized, but yeah, those are some of the newer ones that it's now made available to. And so really the employer, it's their responsibility to provide a space and time for that mom to pump, okay? So obviously some of the common issues that we've been starting to see is the mom may need let's say just 4 times a day, 30 minutes a day to pump, okay? And so the employer's, Lacey, do I have to pay for that time? That's a lot of time that she's taking away from pumping. So that time would not need to be compensable. The only time that it would need to be compensable is if that employer is already providing, let's say, a 15, 20-minute break, right? And the working mom chooses during one of those breaks to take one of her pump breaks, just like every other employee that's being paid during that time, then the working mom would need to be paid for that time as well, even though she chooses, that as one of her breaks to do that. So a lot of folks aren't familiar with this, but they do have the right to pump at work. And like I said, the space, it needs to be free from intrusion. So it needs to be, I do have some door hangers back there in the back in Spanish. I don't have any in English right now. And I do have some cards back there. So basically it's just having folks aware that they do have that right to pump at work. So we do see in the fast food industry, right? They're very small locations. They may have like one little office space. So that's the employer's responsibility to make that space, turn it in. They don't have to make it a permanent space, but when the working mom needs that space, and they need to make it available to that mom. Okay? So now you know the Pump Act, a little bit about the Pump Act. Okay, overtime. This is one of the most common violations that we see with wage hour division. You would think it's easy, right? Get paid time and a half after 40 hours in a work week. But this is, again, one of the most common things that we see. Workers being paid straight time for overtime, not receiving any type of overtime at all, time and a half, or the employer may be paying on a bi-week period and they spread these hours across the 2-week period. So you might have a worker that's working 42 hours in week 1, 38 hours in week 2, and together that's 80 hours, right, in the pay period. And that's what you'll see on sometimes workers' paychecks. Technically, they should have been paid 2 hours of overtime in week 1. Okay, so every work week is going to stand alone. And this third bullet point, I've had employers, I ask them what their work week is, and they're like, what do you mean? It's Monday to Friday. Well, you're open, I'm only open 5 days a week. I understand that, but you still have to have a 7-day work week. You have to know when the work week starts, when the work week stops, so that we can know when those hours are going to, start and stop to calculate for this overtime, okay? And then every work week is going to stand alone. And so we're going to go into a couple calculations, just a general overview of some of these calculations and some of the things that we see that are common. So again, still the basic principle of taking that gross weekly straight pay and dividing it back by all hours worked to get your regular rate, okay? We're checking to make sure it can't be below the minimum wage. And then this last bullet point here is, again, adding in all of those total earnings. If you're getting a commission, if the worker is getting some type of non-discretionary bonus, right? So any of those things you would have to include that into total compensation. And so here's the calculation. It's easy, right? A lot of words on here. So obviously, step one, you're going to take your hourly rate. So if, we have a couple examples after, so I'll briefly go through the slide. Your hourly rate times all the hours worked is going to be your hourly pay due, okay? Then your total compensation, you're taking your hourly rate plus any compensation that we just talked about, any type of other bonus, commission, and so forth, that's your total compensation, and then you're dividing that back by all hours worked for that work week, and then that's going to give you your regular rate, okay? Now, that's all straight time. On the right side, for 4, we have to take the additional half time because time and a half over 40, right? So straight time is all been paid on the left side. Now we're doing the additional half time. So the regular rate times 0.5 or divide by 2. And then obviously you're taking that times the overtime hours worked, and then you're going to combine and add those up. And so here's an example. We have an employee who makes $750 for this work week, and they worked 50 hours. And this is what we see a lot of in the restaurant industry. We have a lot of the back of the house workers, right? They're usually going to be paid on a salary basis, and they're not going to receive any type of overtime. This is just what they'll get, the $750. And they're working 50, 60, 70 hours in the week, and they're not getting paid any overtime. So this is fairly simple of where we just have the hourly rate, and the regular rate's going to be the same, right? So we're taking that $15 an hour, that's what they're getting, times the 50 hours that they worked to get you $750. And then we're taking that times 0.5, the 15 times 0.5 to get, the half time. And then we're taking that times the overtime, the 10 hours of overtime that they worked to get $75. And then we're combining those, and that's the total due down here at the bottom for this calculation. Okay? So this is what the workers should be computing or checking to make sure that they're being paid correctly. Because a lot of times they'll just accept the $750 in cash. And they're missing out. So bonuses, again, as I mentioned before, this is something that we've been starting to see a lot of. So employers, they promise you, if you do ABC, I'll give you XYZ, production bonuses, attendance bonuses, and so forth. The employee is aware and knows that this is going to happen. If I do this, then I'm going to get this amount or so forth. It could be on a weekly basis. It could be on a bi-weekly basis. It could be quarterly. It could be yearly. It could be monthly, whatever. It's the employer's job to understand what's that representative period that this bonus is representing, because that's what we're going to look at. We're going to ask that employer, okay, you're given a $50 bonus. Is it for just this week, or is it for the quarter? Because we have to know, because if it's for a quarter, then we have to go back and look at the 13 weeks in that quarter and see if that employee had worked any overtime. If they did, then we're going to take that bonus, divide it, between the 13 weeks or spread it across the 13 weeks, and then take it by those hours to see what their regular rate is, because it's not going to be the same as what it has been before. And so here's our example again. Same thing, $750 a week, 50 hours, but now they received a $150 bonus for meeting a production target, okay? And this is, again, one of the common violations that we see. So now you can see the hourly rate is $15 an hour, but look at the regular rate. It's $18 an hour. It went up $3, okay? So again, the same thing as we're doing the same calculation, but on step 2, that's where we're adding that $150, the total compensation, dividing it back by all hours worked, and then now we have that new regular rate of $19 an hour. So that you can see is an issue, where employers are not going to be compliant, and the employees are missing out on all their full money, including that regular rate. They should earn $3 more. Okay? Flat rates or day rates. This is something that we see definitely in the construction and landscaping industry. And so, they'll pay this regardless of, the number of all the hours and so forth. Like that's, what happened. Here's $200, here's $150, and the employers are not really tracking the hours that they're working, right? They still have to do that. They still should be keeping all hours worked for all the workers, okay? And so here's an example of this. So here, $200 a day. That employee worked 5 days for this employer, and so they worked a total of 45 hours this week. So when we do this calculation, this is what we're going to check for. So we'll compute for this, and we're going to make sure that they're paid at least minimum wage. So here they are. They're paid $22 an hour. When we take, the $200 that they make each day times the 5 days that they've worked, and that's $1,000, divide it back by the total hours that they worked that week, which is 45. So yeah, no violation for minimum wage, but that's one thing that we'll check. Now we're going to make sure they're paid overtime correctly, because this is also then where we won't see the additional halftime. And so it's the same process, okay? And again, this is in construction and landscaping that we see this a lot of. And record keeping. So this is obviously a requirement for employers. There's no fancy way that the employer has to, record hours worked. They don't have to have a time clock or anything like that. They just need to make sure that they're keeping the employee's information true and accurate, their address, social security number, date of birth, if there's, minors that are working for the facility. And obviously they want to keep track of that. So if someone moves, they need to have that updated. And they want to keep track of their hourly rate, their hours that they're working, any type of deductions and so forth, because we're looking at that on payroll. And so fact sheet 21, this is the guidance for the record keeping. So this is obviously a best practice for employers, right? This is what's going to be employer's best friend, is that's what we're going to be asking for from the employers. The burden of proof falls on the employer. So we go and we ask the employer these questions. Let me see your records. Let me see that you're paid. If you're paid in cash, that's fine. Show me the cash receipt. Show me the information where you've actually paid these workers and they've earned these wages. I had a gas station years ago. He paid everyone in cash, but he had every pay stub to show that, all the taxes were still taken out, and all the information was still there that he had for his records. Okay. Child labor. This is something that we've seen an increase in with violations, unfortunately, and it can be found in any industry. So obviously the federal law, we have provisions that were enacted to ensure that when young people are working, that the work doesn't jeopardize their health or their well-being, or it doesn't affect their educational opportunities. So obviously we just want to make sure that the workers, the minors that are there working, that they're doing it safely and they're still getting, the experience, to do so. And so here's just some of the requirements that we have. In the state law, I know this last session, we had a lot of communication about child labor with state law and federal law, right? So there were some flags that I was kind of a little scared of. And so I've had some conversations with our state Department of Labor. I have a good relationship with them. I've had the School Board Association. I've had some other Indiana school, school board members and so forth reach out to kind of, Lacey, what's going to happen? What's going to happen? And I could say, the employers are going to be confused because if there was going to be differences. And so I think, the folks that did go in and speak in session, I think they did, do some things to kind of help mirror our laws a little bit, because like I said, a lot of employers don't think of us at the federal level. They just think about the state level. And so our penalties, our laws are going to be a lot more strict than the state level. And so obviously that's what the employer will have to abide by, what the more strict law is. And so for 16 and 17-year-olds, they can work unlimited hours. We just want to make sure that these minors are not working in hazardous occupations. And we do have 17 of those that's been declared by the Secretary of Labor. And so 14 and 15-year-olds, they have hour restrictions, and that's one of the common violations that we see. So we see a lot of 14 and 15-year-olds that are starting to work. They're working past 7 p.m. They're working more than 3 hours on a school day, maybe more than 18 hours in a work week, and obviously that cannot happen. So on fact sheet 43, that was before that, that lists a lot of things of what minors can and can't do. They obviously still have some occupations that they cannot work in as well. So pretty much anyone 14 and up can start working. We do have a parental exemption out there for any minors that are under the age of 14, but that only exempts the minors from the hours restriction. So they still cannot, work in any type of hazardous occupation. And so, some of the injuries, some of the fatalities that we've seen have come from actually parents their businesses, right? So that's why we have this parental exemption in place, thinking that, the parents are going to, look out for the safety of their own children, right? They want them to have that experience. Obviously, they may be the future of their business. And so, like I said, they just can't be working in those hazardous occupations at that time until their time comes. So that's unfortunately just what's been happening here, is what we've seen. It doesn't mean that's common, but just what we've seen before. And so here's just one of the hazardous occupations that we do see. I don't know if you guys have heard on the news the case of PSSCI, PSSI. It's the meat processing packaging plant in Nebraska. That was our biggest child labor case in history with Wage Hour Division, where they found 100 migrant children working in these slaughterhouses, working with all types of equipment that I don't even know would exist in these plants without taking a tour. They're working with toxic chemicals. They're working, with all of these big equipments to cut, huge animals, right? So, and they're doing this in the graveyard shift, third shift. So, that's why we work with school educators and so forth, to kind of let them know what's happening, of what we enforce. And so, thankfully, I think, one of the educators there is saw their students falling asleep in class, had chemical burns on them, and that's what they, were sending us those leads to let us know. So with this equipment, they can't operate it, they can't clean it, they can't set up, or any type of things like that. So, however, though, with child labor, there are some HOs, or hazardous occupations, like we say. There are some of those where they could be exempt because they could learn this as an apprentice or as a student learner. And so obviously they have to meet those requirements in order to do this. That doesn't mean that the employer gets the exemption of, okay, I have this exemption, the employee can do this, the minor can do this all the time. No, there's still requirements set in place for those minors to just learn it, to shadow it. I had a State Department of Labor, it was a tree cutting company, and they were claiming that they were student learners or apprentices, but these minors were operating these chainsaws and these lifts and all these big things to cut trees down on a daily basis. And so that's not obviously what the apprentice program or the student learner program's for. Demolition, roofing, and excavation. Roofing is another thing that we see a common violation on with construction. We're seeing a lot of kids on the roofs. And so obviously this can't happen. They can't be in or about a roof, or any type of proximity of that. And so if you guys do see minors, you're out in the public, or driving around, or you're working with some of the workers that are coming to your organizations, obviously please contact us. Child labor is something that we take very seriously, and we do our best to try to get out on to a job site if it because we don't want a fatality or injury to happen. Okay. So again, they can't be, working on any type of scaffolding or ladders or being any type around that, especially with like excavation, demolition work, and so forth. And there's all kind of criteria, so I'm not going to go into all of it, but definitely these are just some of the child labor, violations that we see. The Family Medical Leave Act, that's another act that we enforce, and so this is that allows workers up to 12 work weeks of unpaid leave. So if you have a worker that may have a birth of a child to care for their newborn up to 1 year, they may have a placement for adoption or foster care, they can take up to 12 work weeks of unpaid leave. We also have, if you yourself as a worker, or a worker that has a serious health condition that they would need time off, then they have this protection, as well as if they have if their parent or their spouse or their child has a serious health condition, they can take up to this leave, use this leave basically, and it's just job protection. So a lot of times employers will run the vacation time concurrently. That's okay. That's the discretion on the employer. Like I said, it's going to be unpaid. And so basically when the employee returns back to work, they have to be returned back to the same or equivalent position as they left. Okay, and they're still going to receive those same benefits, health benefits. If they already had it before, they should still be receiving it while they're out on leave. And so this is sometimes, it's not just black and white with these cases, but we do see a lot of issues with these sometimes. But just want you to know that this is a protection out there for the workers if they need it. I'm almost done here. But then, so again, I know this says warehouse industry, but these are a lot of the common violations that we just went through. And it's not just in warehouse, it's in every industry. We see it in the restaurant industry, we see it in the construction industry, all industries basically that we see, home health and so forth. And then here's some common violations again with the restaurant industry, where we run in minimum wage more. We have issues with the improper tips, right? So tip sharing. I don't know. I'm from Evansville, Indiana, so we have a big case down there now with a diner who the employer was, keeping the tips, making the servers give $10 a week to him and then giving $15 on the weekends to him. And he was using that money to, either keep for himself or to pay for the busters. And so obviously that's against the law. Kitchen staff, your cooks, your dishwashers should not be receiving any type of tips. So the tips, should only be going to the servers and then anyone who would be able to be included in a tip pool. Okay, so that's something that we see in the restaurant industry. And then, the pre-shift, pro-shift work, we kind of talked about that, and like those improper deductions. Those lunch deductions, uniform deductions, that's when workers need to be paying attention to make sure that if they are having deductions, that they're not being brought below minimum wage, okay? I think I have that in maybe the next few slides. But retaliation, obviously, again, employers cannot retaliate or discriminate against someone who files a complaint with us or who participates in an investigation with us. So when our investigators go out to the employers, they will talk to current and former employees. And so that employee, they have the right to speak with us and talk to us. And it is confidential when we talk to those workers. We don't share any of that information with the employer of what we discussed with that employee, okay? So any type of, employer terminating or an employer threatening someone's job and immigration-based threats, that would be a form of retaliation, okay? And we can handle that. And how to file a complaint. So some of our cases come on complaints, but not all of our cases come from complaints. So that's part of my job when I'm not doing outreach. Then I'm also spending time looking across the state of Indiana where we have vulnerable workers in industries where they're less likely to file a complaint, right? So we know there's workers out there who will never file a complaint with us, but we still need to check to make sure that there's compliance in those industries that they're working in. So typically when we take a complaint, you'll call us. And we'll take that by phone. I think the state, they have a form you can fill out. We look at all the employees within that enterprise within a 2-year period, okay? So I think the state, they do something a little different where they may just look at that one individual who's calling to file a complaint. But if you're filing a complaint, we're gonna look at you and all employees within that 2-year period, okay? We can go back to a 3-year if we, during our investigation, find that the employer is being willful, okay, in doing it. This, I think fourth bullet point, very important. We do not ask about the immigration status of a worker, right? So the workers are here, they're working for the employer is benefiting from that work. They still need to be paid for the hours that they've worked, whether it's in cash, whether it's check, however they're paid. So we never ask the status of a worker. Okay, so they can file a complaint. We'll ask, obviously, their information because we want to have that information on file. We like to keep our complainants up to date every 30 days throughout the investigation. And there might be some other information that we may need to gather, from them, but we never do ask about their immigration status. I think that's one of the things that folks learn when they hear our presentations, because I've already spoke to several of you guys in here, and wow, I didn't know that. So hopefully that's one thing you've taken away today. So is that you can still contact us, you can still help us with that. And then here's just a list of folks who can file a complaint. It doesn't have to be the employee, it doesn't have, it could be also from a parent, it could be from an advocacy group, it can be other agencies. We've even had other employers call on their competitors and let us know. So. And then here's just some information that we would take, if you were to file a complaint, the employee's information, obviously, if they have any type of pay stubs, records of hours worked, that's always helpful, but it's not required. And then the employer's information, okay? And then just here is some links, obviously, that we have. And then this is our website. This is the easiest way. This is our public phone line here in Indianapolis. So if you have any questions, we do have folks that are experts on the line answering phones in any language. We can speak in, we have translators that can help in over 200 languages. And so, they just have to request that we need, this language assistance. And then we can help. We can help employers if they have compliance questions. We can help workers if they have issues with that. And then here's my email address. And that's all that I have. Yeah, I'll go back one. Yeah, so you can have that. Yeah. You want this one right there? Yeah, okay.
Thank you, Lacey. Thank you. That was a lot of information, breadth and depth. Lacey will take a few questions from the audience. And please.
Okay. All right. When does it make more sense does it matter to report something to the U.S. Department of Labor versus like the Indiana Department of Labor? Like, what do you recommend?
Yeah, so obviously, like I said, we can enforce the federal minimum wage of $7.25. So this example I can use is like sometimes we'll have folks call about a last paycheck, right? I didn't receive my last paycheck, and we ask them, okay, how much were you paid? I was paid $15 an hour. Okay, how many hours did you work? Oh, I only worked 35 hours that week. So technically by law, we cannot enforce the $15 an hour. Legally, we have to tell them $7.25 an hour if the employer was to ask. So in that case, we would probably refer that worker to the State Department of Labor because don't quote me, but I'm under the understanding that they can enforce a promised wage. I'm not for sure. But I mean, you'd have to contact the State Department of Labor, but that's my understanding is that they can enforce that promised wage with that. Now, if they worked overtime, we for sure can lock in that rate. So that's an example that we would do that. I'm trying to think if there would be any other. That would probably be the most common of what we would have them. Another thing is like to think about because, we look at all employees in an investigation, whereas the state's only going to look at the one. So like even with child labor violations, right? So a lot of times if you look on the state website, if an employer, if they had a child labor violation, I think they get a warning the first time. Whereas us, we're going to assess a civil money penalty, and we've actually increased those civil money penalties, and it could be over $15,000. So a warning to $15,000, that's a big difference. So that would be the most common thing. It's probably a last paycheck. We still do last paychecks. We can still handle those and conciliate those. We try to do those as quickly as conciliating rather than doing a full investigation. But, like realistically, we want to also work with our other state partners if they can handle something a little bit more, with versus us. We obviously want to make the biggest impact that we can make and try to help the most workers that we can help. Good question.
Anyone else? Question?
That bread smells good. I don't know. I smell bread. It smells good.
Hi. A question regarding the immigration. So you mentioned a complainant isn't asked about their immigration status. Mm-hmm. Do these things, the Fair Labor Act, does it cover every employee regardless of their immigration status?
Yes, it does.
Or is it just the complainant that doesn't get
No, it protects all workers. Yeah, so it doesn't matter your legal status. Like I said, if we have, 20 illegal immigrants in the kitchen in a restaurant, we're still going to make sure that they're paid overtime and minimum wage. You're welcome.
One more from Angela.
Angela's going to ask me a question.
I just have a question. Can you explain the difference between exempt and non-exempt for?
Yes. Yeah, so non-exempt, so if you don't have someone paid on an hourly rate, right, so you can have non-exempt employees and you have exempt employees. And so exempt employees are typically going to be paid on a salary basis, and they're going to be exempt from minimum wage and or overtime, okay? So when you hear maybe the terminology 541, or you might hear a professional or administrative or executive employee, right? That typically is going to be an exempt employee. And so that's what I'm saying, that's when employers need to know of, are they going to classify non-exempt employees? Employee can still be paid on an hourly basis, a salary basis, but they just have to, the employer has to understand, okay, are they non-exempt or are they exempt? Because, they would still have to pay overtime to the employees who are classified as non-exempt. And that's what employers will say, well, then what's the point of paying them a salary if I have to pay them overtime? What is the point? Just pay them an hourly rate, but you want to pay salary, that's okay. So as the employer. That's a very good question. So did I answer that good enough? And we've actually had new guidance, a new final rule come out on that. So with the exemptions, the salary basis used to be $684 a week. Now that's increased to $844 a week as of July 1. And then we have another increase that's going to happen on January 1 of 2025. Then employers will have to move up, and that's over $1,000. I think it's, I don't know the number, I think it's 1,100 and something. And so the employers have to make that decision. Do I want to continue to pay this salary basis on this, or do I want to drop these employees down to hourly and then pay overtime? And they have that discretion to do that. So, and then I think in the next 3 years, it's going to go up again. And, obviously Congress has passed that, but to me, I feel like that's going to really be beneficial to a lot of folks that are in the restaurant industry, like for managers and so forth, because they're putting in so many hours and they're barely getting by with that $684. So that's going to help them tremendously, that are managers in the fast food, not just them, but that's just kind of what I think on that part. Love for little thing, but.
Thanks again, Lacey. We'll have another chance to ask Lacey questions after a while. At this point, let's take a 15-minute break. We are fortunate to have a distinguished and experienced panel of folks to talk about some deeper, perhaps, and some wider issues about immigration and immigrants and labor law. Lacey told us a great deal about wage and hour, and we have some other folks to talk about some very closely related subjects. Once again, if I went through all the qualifications of our panelists, we'd be here all day, so I'll be brief. Aaron Loomis, to my immediate left, is a district director for the U.S. Department of Labor, Wage and Hour Division, Indianapolis office. His division enforces federal laws about minimum standards for wages and working conditions, and as we heard from Lacey, record keeping, child labor, special employment, family medical leave, and so forth. Angela Adams, next to the end, is a distinguished attorney. Before law school, before she decided to take that path to law school, she had a real job where she was a consultant for the Indiana Department of Education Division of Language and Language Programs. She taught English in Mexico. She's fluent in Spanish. She's past chair of the American Immigration Lawyers Association Indiana chapter. She is consulted by the Indiana General Assembly on immigration policy. It's good to know they like to hear from people who know what they're talking about. She counsels the ACLU in the past to oppose parts of Indiana immigration law that eventually were struck down as being unconstitutional. She's been a force behind the compact of principles to guide productive discussion about immigration. Karen Maher is a director of Anti-Trafficking Initiatives for the Indiana Coalition to End Sexual Assault and Human Trafficking. She's had 20 years in public service. Once again, she has been in the trenches. She's represented children in abuse and neglect cases. Cynthia Hernandez is Program Director for Foreign Labor Certification and Migrant Seasonal Farm Workers for the Indiana Department of Workforce Development. Her department is in charge of reviewing and processing permit applications. She is deeply involved in various organizations that help migrant farm workers. I have a couple of questions for our panelists for each of them, and then we'll open it up to the audience for more Q&A. Let me ask Aaron first. I think we may have touched on this, Aaron, but do all labor laws, federal labor laws, apply to undocumented immigrants?
Thanks, Kent. Thank you, Coyne, for putting this event on and for having us. Yeah, as Lacey mentioned, our agency, we're not concerned with status. We don't ask workers, are they documented, are they undocumented? We do an investigation. We're looking at all workers the same. We don't bifurcate who's documented, who's undocumented. They apply to all workers. I was an investigator. I was in the field for 10 years prior to entering this position, and I never ask a worker, what's your status? Never ask employers about legal status, immigration status. It's just not something we're concerned with when we do our investigations.
Good. Thank you. Let me ask Angela. Angela, this is a question that comes up in social context and in political context. Why can't undocumented immigrants just fix their status and get citizenship?
Wow. How long do we have?
Why don't they just do that?
Is this on, by the way? First of all, I feel like very honored to be sitting here in front of my longtime idols, Dion and Clyde, because I watched you on TV growing up. So I'm all nervous and giddy up here. Anyway, thank you, Coyne, for having us. That is a loaded question, but one I have been asked countless times ever since my days at the Indiana Department of Education with Maria. And people would ask us, why can't they just get legal? Why can't they just go get their citizenship? Why can't they just get a work permit? And those things aren't possible for people who entered the country illegally without inspection, or for someone who's in the United States without status. only in under certain circumstances. Employers all the time ask me, I will do anything for these workers. What can I do to fix their status? And frankly, there's nothing we can do most of the time if the person is here and they're undocumented, because there's something called the 3 and 10 year bar. If you leave the country and you've been here for over a year without status, you're going to be subject to a 10-year bar. So you can't just go back and come back the right way. That is legally impossible in most cases. So if you hear, politicians or whoever say that's not even a possibility. The laws need to change. I just want to underscore that also have this conversation almost every day with potential clients. Just had it today. Well, I just want to get a work permit. Can't I just get a work permit? The answer is no. There's no just work permit. There's no application for work permit unless you're going through a process like asylum or like a marriage-based petition or like an employment-based pending case or or you're in removal proceedings. Frankly, you can probably get a work permit then. But you have to be in a pending proceeding in order to be able to get employment authorization as ancillary to that pending process.
Thank you, Angela. Karen? How is labor trafficking defined under federal and state law? What is labor trafficking?
Yes, so also thank you to COIN for having us and for highlighting these issues today. We really appreciate it. So under federal law, the definition of labor trafficking is the recruiting, harboring, transporting, obtaining, or providing somebody for the purpose of labor or services through force, fraud, or coercion. For involuntary servitude, slavery, or debt bondage. So a lot of words in there. I'll break some of that down in a second. I will say our state law on labor trafficking is pretty similar to the federal law. It has a lot of those same elements in it. We get a lot of questions about what's the difference between labor exploitation or wage and hour violations versus labor trafficking. And really the key is whether a person feels like they can physically leave the situation they're in. And that's where that force, fraud, or coercion comes in. It may be one of those elements. Very often it's a combination of those things. So it can look like somebody who's undocumented, they were offered a job once they got here, and then their status is held over, or their lack of status is held over them as a threat. We're going to report you to the authorities, you're going to be arrested, you'll be in jail here in the United States, or we'll get you deported. It could be somebody who comes in with status, somebody helped them get a temporary visa, and then once they arrive, and this is a very common scenario that we come across, a trafficker will take their visa, any identification paperwork they have on them, and then they can no longer show that they're here legally. They can't show who they are. They don't have a support network. Maybe they're being threatened with, you'll never see your family at home again. And so it really comes down to, do they feel like they can leave that situation? And if they're at the point where I'm afraid to leave, I have no other choice, I have a debt that they believe that they, have to pay off before they can go, it's more likely labor trafficking than just labor exploitation or labor violations.
Thank you. Thanks very much. Cynthia, you work in a very important area of migrant laborers for the most part, and migrant employees here. How are those issues of seasonal and migrant workers addressed by you and your department and the legal system?
Thank you for having us. So we work with migrant and seasonal farm workers here in Indiana, and we have a complaint system in place. So anytime we are out in the field and we observe or we hear a violation, we report it immediately to our state monitor advocate. Her name is Joanna Mejia. And she will then contact the employer and try to resolve it at the local level with the employer. If the employer chooses not to cooperate with us, or they are unable to address the issue, what we do is then we pass it over to an enforcement agency. So I work with the Department of Workforce Development for the state of Indiana, and we are not an enforcement agency. So we review the job order. We work with the farm workers and with the employers so that they know the terms and conditions of the job order. If there is a violation and we are unable to address it, then we work very closely with Lacey and her team, and they are the enforcement agency. So we let the employers know immediately when we get a violation, we want to work with you at the state level, we want to help you, but if you're unable to do that, we will have to pass it on to an enforcement agency. Everyone seems to want to work with us at that time. And we try to resolve everything. A lot of the times, the employer is also unaware of the violations that they're doing. So we try to work with both of them, and we're also here for the workers. And I want to thank our team, Maria, Mary, and Terry. Because of them, we are all out in the field with the workers. We work after hours. Maria and Mary are out there sometimes in the fields in the evening with the workers.
You also work with the Mexican consulate, don't you? Aren't they out in the field as well?
Yes.
Representatives of the...
We have an event that we do to the farm workers every year. Carla, thank you to Carla, because we work very closely together, and every year we've had a great event where we help more than 100 farm workers.
Thank you.
So we work with a lot of organizations, not just with the consulate, but with Wage and Hour, Indiana Legal Services. So we thank them for everything that they do for us too.
It's a lot of collaboration, and
Yes.
it makes the job much more effective, I'm sure.
Yes.
Thank you for all the groups, all the groups. You may have noticed that Aaron is on crutches. He had an injury Monday, but he nonetheless came to this seminar today, came in on a little scooter, and was quite a trooper. So thanks, Aaron, for going the extra mile, kind of on one leg. Lacey told us about retaliation and what remedies are available. As a practical matter, though, there's terrible unequal bargaining power between an unscrupulous employer and an employee. How can the abused, cheated, maybe undocumented employee safely get redress, safely find a remedy, safely make a report?
As Lacey mentioned, we have a public line. It's confidential. It's 866-4 US-WAGE. Workers can call that line. Again, they'll talk to a live person. That person will not ask about status. We're not concerned with that. If there's retaliation that's taken place, the worker asks about overtime, for example, and then the employer says, yeah, if you keep asking about overtime, I'm going to report you to immigration or what have you. I'm going to cut your hours. I'm going to cut your pay. There could be protections there, and they should call our office. We can talk about that. Retaliation has been it's been kind of a hot button issue, as Lacey mentioned. We had some good press on a case down in Evansville with the employer down there. He owned a restaurant, and some of the things he was saying, some of the threats he was making to employees. We had a great resolution there. Yeah, I think the biggest thing workers need to know is that it's a confidential process. If we initiate an investigation, we don't give the reason for an investigation. We handle all investigations the same, whether it's complaint-driven, whether it's agency-initiated. We don't reveal the reason for an investigation. We don't let them know we have a complainant. We don't give a name, anything like that.
Thank you. Thank you very much. Karen, Cynthia talked about collaboration among agencies. In your very difficult area about trafficking, what cooperation exists? What cooperation have you found to be most effective in dealing with trafficking?
Yeah, so collaboration is critical in the field of trafficking because there's no one agency that can cover the complexities of it by itself. So our agency co-chairs IPATH, which is our State Human Trafficking Task Force. We co-chair it with the U.S. Attorney's Office for the Southern District of Indiana. And so we have, I would say at this point, about 60 organizations around the state that participate on the task force. So that is local, state, federal law enforcement. We have a whole slew of victim service providers. We have workers' rights organizations like, Department of Workforce Development. We have an outreach and education committee. So a lot of folks doing a lot of different pieces of the puzzle. I see a lot of our partners are here today. So Cynthia, Carla from the Mexican Consulate, Casey Farmer from Indiana Legal Services, who co-chairs our labor trafficking committee, along with head consul of the Mexican Consulate. You really have to have all of those partners in place because there's so many different pieces. And labor trafficking especially is not something we've done a great job of identifying in the state of Indiana until fairly recently. And so getting the word out, doing the education on that is something we've prioritized in the past year. And so even today, though, I'm learning things that I did not know, which is really exciting. I took a lot of notes during the presentations. I'm learning things now, so love making the new connections.
Good, thank you. Thank you. Cynthia, let me drill down a bit further in your area of expertise in your work. What are the specific issues that are, if not unique, are more in the area of immigrant and seasonal workers that you see? Abuses and remedies as well. What things are sort of specific to the folks you help serve?
A lot of the people that we work with, the workers, the farm workers, they, a lot of them now are on an H-2A visa. And so when we meet them, we let them know about the terms and conditions of the job order. The hourly rate for the workers this year is $18.18. So a lot of the workers don't know that, and each state is different. So if they go to another state, for example, Florida has a different wage than we do. So what we do is we let them know what the hourly rate is in Indiana, and any specific information that might be in the job order that is unique to their employer. Every job order is different. So that is one thing that we see a lot is the workers do not know their farm worker rights, and they also don't know the hourly rate for Indiana. And so that's something that we always focus on when we go out there, because that is, wage is one of the issues that we get a lot, is wage related. Employers are either keeping hours from them, not reporting all hours worked, or the employer is paying them less than the hourly rate is in Indiana.
Good, thank you. Angela, I'm going to throw you a curveball. We've both practiced law for a long time. How do you get an employer to do the right thing? How do you get an employer to come up with what he or she knows will cost money or be a risk to the future of the business because they should? Or how do you convince them to do what you want them to do, that is to be legal?
Well, good question. Usually when they're in my office and they're coming to me, it's because they want to do the right thing. So I rarely have to convince them. If there is an option, they're going to pursue that option. It's the challenge is when there's not an option. So most employers, if I have somebody I can help them, I can do consultations with these people and see if they have any options and see maybe there's a route, maybe there's a pathway we can take. Very rarely there is a path, but when there is, most employers that I work with will help, will pay what they want to pay. It's what you called earlier unscrupulous employers that don't seek out an immigration attorney because they're doing something wrong or doing something under the table or threatening, with deportation or whatever. That's where we work with these partners to encourage people to make a complaint and to assert their rights, which they do have because they don't know that they have those rights. But most employers would do anything to help their valuable employees if they could, because so much of their business relies on those skills and those people that have many times worked for them for years, and they've become like family to them, and maybe just found out or just had information that they might not have the proper documentation, where the employer usually didn't know. Usually I'm in my experience, there are a lot of employers I'm sure out there that do know and maybe take advantage, but in my experience, a lot of the times the employer's done their due diligence. The employer, they have done the I-9 form. The I-9 is the employment eligibility verification form. Everybody has to do that within 3 days of hire, regardless. So you've all probably seen an I-9, hopefully, if you're employed, right? Hopefully your employer's doing your I-9 form. But those are done, and then sometimes E-Verify. But E-Verify is not required. It's not mandated by federal or state law in all situations. Only in some situations under state law, if you've got certain state contracts with government, then you must attest or sign a document that says you will engage in E-Verify. But overall, it's not a mandate. So most employers are doing that, but there's so many that present false documents, people that are, and on their face they look real, and the employer's not obligated to look further into that. If the document looks real, feels real, and on its face, the employer is, has done their due diligence, and really at that point, if ICE comes knocking on their door to do an audit, if they've got their I-9s in order, then they're probably going to be okay.
Good, thank you. You want to take a few questions from our audience? Sure. Dion has a mic here, so if anybody has questions, please raise your hand, and we'll try to embarrass our panel.
If and when you do have the employer that is working under a different name, do they still have rights, or them using not their actual documents kind of forfeit any rights that they may have?
So the employee's not working under their
Right.
their actual name.
Correct.
Yeah. So again, the laws would apply to them. We would look at minimum wage, overtime, the tenets of the Fair Labor Standards Act, other labor laws that may apply to them. Now the difficulty may be that most of the time there's back wages due as part of our investigation. Sometimes we have an issue getting the money into the worker's hand, especially if there's a different name. That can be difficult. We were just talking with Carla from the Mexican consulate about Indiana has over $1 million in back wages that for unlocatable employees, basically. We have this money. We collected it as part of our investigation. We just can't find the workers and get it into their hands, unfortunately. So we're trying to find ways to do that, to verify identities, and to get that money into their hands rather than it going to the Department of Treasury. But yeah, it's a different name. They would still have protections. It just may be difficult getting them the money that they may be owed.
And if I could add to that, there's something called a wage claim, and if you haven't been paid, you do have a right to file a wage claim. And one of the other problems is oftentimes the employer, the unscrupulous employer, has either gone bankrupt or fled, and they're not able to be located. And so recovering, even if you can get a judgment against that employer for money that you're owed, sometimes it's hard to recover from the employer as well. Would you agree?
Yeah, absolutely. I think the word of the day is unscrupulous. Those unscrupulous employers that they owe a lot of money, we have seen that they'll file bankruptcy and then they'll close down and maybe open up a different business, or they leave the state and we have trouble recouping those monies. Yeah, that does come up.
One of the things they teach you early in law school is that any lawyer can get a judgment. It takes a good lawyer to collect it, unfortunately.
I just want
Lacey.
to add real quick to Aaron of what he was speaking about on the back wages. So we do have a program, since we do have over $1 million here in Indiana, that needs to go back to 1,600 workers. And so we have a system called Workers Owed Wages. Wow. That's what it's called. Wow. So you can literally just go to Google, type in workers owed wages, and you can help workers. So if you're working with workers now, it's an easy system. They just go on, they put in their employer, whether it's their former employer's name, they put that into the system, and if we have investigated them and they still, are the workers owed wages, that employer information will pop up. They can type in their name, and then it will then put in the correct address. So then that will go to our regional office in Chicago, who our back wage specialist team will then reach out to that worker to try to get that check to that worker. So that's another system, another tool that we have to try to help get these workers who are owed wages still. We see this a lot with the H-2A workers who may go back to Mexico after being here, or like I said, they leave the employer. The employer only has the last address on file, and obviously they've tried to issue the checks, but then they came back. So that's why we have this program. So definitely spread that information. It's on our website, Workers Owed Wages, and that's something that Aaron was speaking about that can help. We don't want this money. Like I said, we don't want to turn it over to the Department of Treasury. This is the workers' money. They worked hard for this, and so we want to make sure it gets back into their hands. And it's very rewarding for our investigators, right? Our investigators are spending a lot of time doing this work, trying to help these workers, and when they don't see the positive resolution of that money getting back to their hands, sometimes they feel kind of like, I didn't do my job enough, so that's kind of to your question of that. Thank you.
Good. Thank you, Lacey. Other questions? There's in back, Whitney has a question.
Hi. For children who are working, right, and they're too young, like you had mentioned, roofing. I see that regularly, where the child is on the premises, sometimes on the roof. But I wonder, when it comes to that, also, where is that line of, is it going after the employer? Is it also opening a DCS case? Is it, like when it comes to minors who are being exploited in that way, and trying to make a call about that for their safety, but also recognizing, are the parents going to be getting in trouble for that at the same time? Is it going to be employer specific? I don't know what you could speak to that if you can.
Yeah, I would say, and this is a little tricky because there's no way to know if you just see a minor on the roof, whether that's potentially labor trafficking, right? I do want to let folks know, though, if you suspect trafficking of a minor, that's always a mandatory call to DCS, because everyone in the state is a mandated reporter. And so it's not something where you have to investigate, you have to conclude it's human trafficking, you have to know for sure. It's just you suspect, maybe it's a young person you see up there repeatedly. There's an older person who, it doesn't seem like they're related to them. Somebody's bringing them to the work site. It seems off, something seems suspicious. I would say make the call to DCS. We actually have our DCS human trafficking team here today. They're another critical partner. And then also on the trafficking side of things, once the other good thing about getting the department involved, if they suspect there's trafficking, they contact the Office for Trafficking in Persons, which is federal agency, and they can potentially get benefits for the child as if they were a refugee. So, and this is true for adults as well. If they are in that type of situation, if you're working with somebody and potentially they're being trafficked, they can contact Office for Trafficking in Persons. You can help them contact the office, and if they get a certification letter, they can qualify for benefits the same as a refugee. So think food stamps and anything related. So there are a lot of resources out there for them.
Can I add, are you referring to the T visa?
No.
No, you're referring to the benefits.
Just the benefits.
So there's something under immigration law called the T visa. If you've been a victim of trafficking, you might qualify for immigration status to apply. We do T visa applications. I know, where's NCLC? They're here. They do. There she is. They do a lot of those too. That's Angelin over there. And also Indiana Legal Services as well, yes. And There's something else called special immigrant juvenile for someone who's been abused, abandoned, or neglected by their parents or guardians, and it's not in their best interest to be returned to their country of origin. That's called an SIJ or SIJ or special immigrant juvenile. So T visa, S visa is another one. We don't see those very often. U visa is for a victim of a crime. Those are some of those humanitarian visas that immigration attorneys can help with in those situations.
And that's the key, to get a qualified immigration attorney. NCLC, Indiana Legal Services, there are services around. You may have to wait a while, but nothing beats good advice. I think we had a question back here.
Yeah, I had to change my question because it was going to be about T visas and U visas. But I actually had a question when Lacey was up, but maybe Aaron can also answer it. It's about tipped workers, like sub-minimum wage. She had mentioned that if you work in a restaurant and you make tips, your employer can't take those from you and then tip out other employees. Back in my good old days, I used to work as, server, bartender, all dishwashers, things like that. And then, so in my days, in those, like even bartending, I'd had to tip out certain employees. Is that, was that not allowed? That's where, because I still have friends who bartend and are restaurant work and things like that, and they still have to tip out, hostesses, busboys, sometimes the kitchen, things like that. So I just didn't know if that was or isn't.
Yeah, no, that's a great question. So tipped employees, for example, the tipped minimum wage is $2.13 per hour. There can be legal, valid tip pools. Let's say it's a server. They have to give a portion of their tips to a busser, a portion of their tips to a host, a portion of their tips to a bartender. That's a valid tip pool scenario. Where employers run into issues is the server has to share their tips with the owner or the manager. That's a big no-no. That creates a lot of issues. What it does is it invalidates the tipped wage, and the full minimum wage would be due for all the hours. It creates a huge back wage burden. Also, tipped employees that are sharing their tips with traditionally non-tipped employees, like back of house cooks, dishwashers. The retaliation case, there was something to that of you had servers that had to share their tips, and then the employer was using that to supplement some cook wages, is what we're hearing, and it creates this issue. And yeah, so there are instances where there's going to be a valid tip pool scenario, and then there's going to be those instances where it's not. But tips are the property of the employee. Anytime an employer gets involved and keeps those tips, it's going to create an issue.
Question. Any other questions? Please. Deanna will bring you a mic.
Thank you. I actually have two questions. And the first one related to the tipping. Is there a difference, and I mention this because I recently went to a restaurant and I appreciated the work that the lady was serving me. Is there a difference between when she brings the receipt and there's a suggested gratuity and I'm paying with a credit card and I'm paying 25% versus when I pay in cash? Will she receive if I wanted to tip her $15, for example, and I gave her that amount in cash, if I had added it to the receipt, will she get the $15? Or what goes behind that?
Yeah, that's a good question. So how we enforce it, there is a difference between a tip and a gratuity. I think a lot of people hear tip and gratuity, they think it's synonymous. A gratuity, a service charge, mostly we see that for large parties at a restaurant. The employer, the restaurant will add 10%, 15%, 20% to everybody's bill. I would say for the unscrupulous employers, they can keep that. That is not owed to the employees. It's a gratuity. It's a service charge. What we see most of the time is the employers, they just give that to the workers. With my wage hour background, whenever I see a service charge or gratuity on my bill and I'm at a restaurant, I always ask the server, do you get to keep this service charge? And I can't remember an employee that's told me, no, I don't get that. And then you have tips. The tips, yes, if you're specifying an amount to an employee, they should get that unless there is a valid tip pool arrangement. I hope that answers the question. But
It does.
Okay.
It does. Thank you. And my second question, I was just wondering, with the upcoming election, are there any relevant changes or any information as it relates to immigration law with whichever party wins that some of you can inform us about, or just as updates?
While they're thinking, let me suggest that each month COIN has a virtual meeting, second Tuesday of each month from noon till 1. It begins with an immigration law update. And we've had these talented folks and a lot of other folks in the room give us wonderful information every month about just that question. What is the change? What have the changes been? What is kind of predicted? So with that in mind, I'll ask Angela to.
Well, based on personal experience and history, if history is any indication, if Trump is elected, we will probably lose all TPS categories. We will probably lose, they'll try to challenge DACA, keep challenging DACA, and the parole in place will be gone. This new parole in place through Keeping Families Together, which is through the Biden administration, that's currently being challenged by 16 states, has just been stayed again until September 23rd. And so those are some examples of things. What'd you say? Refugee cap, thank you, will go way down. Enforcement priorities will also be different. Anyone will be a target. Anyone, women, children. It doesn't matter who you are, if you're a criminal or not. This is based upon fact. Being an immigration attorney under a previous administration for 4 years and living through this, that will happen, I can assure you. So that's kind of scary to think about in my world. So.
Do you remember in the past we had family safety planning clinics where we helped people get through the awful situation, the specter of having the parents, undocumented parents picked up, kids who were born in the States remain here, and the purpose of our clinic was to have standby guardianships. Heaven forbid we go back to that. Question.
Yes, as just kind of a follow-up, is there any non-legal advice that as an advocate we are able to share with our clients that may or may not begin to freak out a little bit later on as time goes by?
Can you elaborate?
Well, just kind of what you were saying, like if Trump wins, you know, all the effects that are going to happen.
Mm-hmm.
People, of course, since we don't know, everything is an uncertainty right now, and when people, our clients do start to freak out, is there anything that we can tell them that isn't necessarily legal advice to, I guess, calm them down in a way or give them some peace of mind or something like that?
Well, I probably shouldn't say this, but I'm very vocal in my consultations with people about what will happen under a new administration. And because we've lived through a previous administration and we know for a fact that history is there. It's on the books. We're not predicting. We're not guessing. This actually happened. So you can tell people this happened before and it will happen again.
Not very reassuring, though.
I should have maybe added, or I guess a way to prepare for.
So like the safety planning clinic.
Yeah, I would say that. I mean, hopefully we don't have to go back to that, but identifying someone who can take care of the kids, identifying someone who can pay the mortgage or take care of bills or a bank account, maybe doing a power of attorney, having a power of attorney in place, which would delineate all of the duties that this person is in charge of. If there's an event, it's called a triggering event. And this triggering event would be X, whatever X is, then these powers go into place. That anyone can have that. Anyone. You don't have to be an undocumented immigrant to have anybody. I have a power of attorney, along with my trust and estates work, with my will. It's just one of those documents that everybody should have, regardless. If something happens, this is how you're going to take care of it.
Karen?
Yeah, no, and I was just going to say this really highlights the importance of knowing who your legal partners are. that are doing this work, like Angela, like Indiana Legal Services, Neighborhood Christian Legal Clinic, and maybe some reassurance, you know, not to say, we know this is down the road, you're gonna have this or that happen to you, but if something goes this route, we have legal partners that you can talk to know your legal rights, who can advocate for you so that they know it's not just a dead end and there are other places for help.
Good, thank you. Please, go ahead.
Yes, please. And in that, the safety planning and what, just in case, remember your schools have social workers. And that's one of the things that we work with families that let us know what's going on so we can offer the McKinney-Vento support so that we can make sure that we know how to help the child and keep them in school if there's a child involved.
Let me ask a question to the group at large, if I may. Situation was reported in southern Indiana, a group of immigrant workers, documented, are being hassled by local citizens. I'll be polite. I don't know if the law enforcement locally is interested. I don't know if the local politicians are interested. Do you have any ideas of what people can do in this context to protect these folks who all they want to do is make money and send it back home? Suggestions, practical suggestions, please. Southern Indiana, I'm ashamed to say.
Where?
I don't want to say.
Oh.
I don't want to say. It's in a county that would not surprise you. What do you do?
I would say get educated on what immigrant populations are dealing with, why they're coming here in the first place, instead of making assumptions and, you know, getting lost in all the hyped up media and biased news and everything else. Really do some educating of yourself. There's a lot of resources out there that do training around, you know, whether it's human trafficking or related issues and how these populations are affected, why many come here. Like you said, supporting families at home or leaving a country that's really violent, not having a safe place for their children to grow up. I think if local communities understood that better, it would be easier to counteract the narrative that these are all just, you know, illegals coming across the border and they're taking jobs and, you know, all the other things that we've heard. Once you actually know what's going on the ground, it's easier to help educate yourself and others.
Any other thoughts, suggestions?
Yeah, I 100% agree with all of that, but I want to find them some support people down there, so now I really need to know where it is. I'm going to find them some people.
You may be contacted right after the meeting.
I'm going to put some nurses on it. How
There's
about that?
There's a good chance.
There'll be some good supports.
There's a good chance.
Nurse Family Partnership. We have 62 counties with Goodwill.
I can't express my gratitude.
Maybe we could use Goodwill. We have 5,000 employees. We could do an education session, then send them to Raleigh.
I want to thank all of our partners, all our participants here, Aaron and Karen and Cynthia and Angela and Lacey. What a great afternoon. I learned a lot. I hope you did too. I hope also you learned where you get more information, where you get help and expertise. We're all in this together. I also want to thank the JCC. There is a QR code on the back of the chair in front of you. Tell us how we did. We want to improve programs like this. There are a couple of questions in there about the JCC. If you want information about the JCC, there's a table here. It's a wonderful place. Once again, the Social Justice Fund of the JCC has underwritten this program. Camille Arnett, who's co-administrator of that fund and the director of our Arts and Education program, is here. Do you want to say a word, Camille?
I just want to thank everybody and also thank Kent for being the ringleader of this. This is a really important and special event for us with Arts and Education. Education is half of what we do. Every year we have a couple dozen programs throughout the year that are a mix of both free and paid, but especially when we have events like this that are education, social justice based, trying to raise awareness in the community about important issues, those events are free. Additionally, every year the Arts and Education Department runs a festival of books and arts, and that is also a mix of both arts and education. That's coming up in a month. We are a really diverse and rich community center, so if you have any interest in learning more about the JCC for yourself or for your organization, any type of potential partnerships, events like this or others that we could do, come talk to me. You can get my card, you can get a membership information folder, you can get a bag clip up here as well. So thank you all for coming to the JCC, and is that it, Kent?
That's it. Thanks very much, all of you. And if I didn't mention it before, please help yourself to the food.